Oh. Did I send it to you? I did not. I'll set the probable cause out. I'll just set it out since I took him into custody. I'll set it out next week, May 16th, 2024, 9 a.m. Court does call the case People versus Yusuf Cyrus. Who is this? Who? Far out? Oh, here. Hang on. Bring it back. Yeah. Step back a second, sir. I'm sorry. Court does call the case of People versus Mohammed Farah. Okay, what are we doing? Discovery is complete. Of course you would. Discovery is complete. People had their witnesses available the 21st. Preliminary examination will be set May 21st, 2024, 9 a.m. That is before Judge Valvo. As to bond.
Thank you. Regarding bond, Mr. Department does have another matter. Your religious bond is $2,625. He tells me that he intends that they post that he's granted a PR on this case.
Did he post it?
No, he doesn't intend to. If the court inclined to grant him a personal bond on this matter, he does have.
So we get into a chicken or the egg because I'm not moving it if he's got another bond.
And other cases of CCW use.
Thank you.
That's correct, Your Honor. Would it be more appropriate to raise that preliminary examination after he posts the bond on the other matters?
I would think so. Judge Valvo would be more than happy to hear it.
Thank you.
At this time, motion for bond reduction is denied. Bond will continue. Thank you. Parker recalls case People versus Yusuf Cyrus. Thank you.
Your Honor, we're just asking for a 3-week adjournment to submit mitigation information to consideration.
May 30th, 2024, 9 a.m. without objection. Bond continued. Thank you. Court calls case People versus David Davis.
Good night for the people.
Good morning, Your Honor. Judge Overwater, this is what we've done on behalf of Mr. Davis. Approaching. Mr. Davis, would you state your name for the record? Mr. Davis.
What are we doing?
Court plea agreement, plea form was sent to the court last night.
A plea form that indicates he's going to plead to attempted resisting and obstructing the 1-year offense. Upon a successful plea to that charge, counts 1 and 2 are dismissed. That's the court's entire understanding of the agreement.
Correct.
Yes, sir.
Sentence 1.
Okay. You saw the 200 part of testimony about the truth and all the
Sir, it is this court's understanding you're going to plead guilty to the charge of attempted resisting and obstructing a police officer. That is a misdemeanor punishable by up to 1 year incarceration and or a $1,000 fine plus court costs. You understand that? All right. You understand also, sir, that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Barr in 14A2 District Court. All right. Understanding all of that, do you still wish to plead guilty? And to that charge, how do you plead?
Yes.
Now, you understand that by pleading guilty, you'll not have a trial of any kind. You signed an advice of rights form, is that correct? Any question regarding any of those rights? Please look at paragraph 5. You'll see a copy on the podium. Look at paragraph 5. Those are your rights which are part of a trial. You understand that by pleading guilty, you'll be giving up those rights as well as all the rights on that form. You understand you're giving up your right to appeal of right. Are you on probation or parole? Has anybody promised you anything other than what's been stated here today on the record to get you to plead? Anybody threaten you or coerce you? You're doing this voluntarily of your own free will and because you believe that you are indeed guilty of this offense? On the date of February 29, 2024, at the location of Buckingham Drive near Hamlet Drive, Superior Township, Washtenaw County, State of Michigan, did you come into contact with Washtenaw County Sheriff deputies? What happened?
I was in the garage. I told him to come out to the garage and I'm waiting for him.
How'd that work? Yeah. You kind of came out of the garage. Yeah. You have no dispute they were giving you a lawful command to come out of the garage, do you? You're not disputing that it was a lawful command they were giving you to come out of the garage. You just didn't come out. Well, not. But you eventually came out. Yeah. Counsel, I complied with the court rule. Would it be proper to accept this defendant's plea?
That's satisfied, thank you.
Court will accept the defendant's plea of guilty to count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered at 1482 probation. Sentencing in this matter will be when? July 9th, 2024. What time? Doesn't matter. 10 a.m. Before Judge Barbon continue.
Thank you, Your Honor.
It's 60 days. It's 2 months. Okay? Emily, I'm just counting. I don't know. Court calls case People versus Wayne Franklin. Your name, sir. Thank you. What are we doing?
Your Honor, that's this matter for preliminary examination. I would ask the court also to consider a bond.
Discovery complete on both cases. People have their witnesses available the 21st. Preliminary examination will be set in person, May 21st, 2024, 9 a.m. before Judge Valvo. That's the bond.
Your Honor, it's my understanding that the complaining witness in this matter is likely left the state. She does not reside with my client. He has his own place that he'd be staying at. My client has 2 jobs. He works for a cleaning service called Arrow Cleaning, where he works nights. He also works at AF John, where he's a property manager for various strip malls. He resides on Alpine Drive. His mother also lives locally. He has her support. I'd ask the court to consider releasing Mr. Franklin, personal recognizance bonds. We'd be happy to comply with the tether requirements the court felt if they were necessary. The allegations in these cases are not particularly aggravating. There's been, to my knowledge, no indication that he's had any contact with the complaining witness since he's been incarcerated. So I would ask the court would be willing to consider his release today. He has reported to me that he is the only provider for his family. His wife does not work, and if he continues to be incarcerated, he will lose his local insurance.
Respond.
I first want to note out the gate that he has bond denied out of 15th District Court, and that is not up until May 15th. But on the attempted home invasion case between April 7th and April 11th, the defendant assaulted and stole the victim's iPhone. The defendant was released on a PR bond on April 19th. It was prohibited from having contact with the victim or going to the residence. On April 24th, he told the victim that he was allowed to have visitation with the children and came to the residence. The victim, after that, then called the court and learned that what the defendant told her was a lie. The defendant has repeatedly harassed and texted and called the victim, resulting in aggravated stalking charges in the case 24 F55094. In the attempted home invasion, he violated the no contact order, founded on the defendant's words, or founded on the victim's causing damage to the street. And it was so loud that it caused the neighbors to take notice and filmed the defendant leaving the scene. I also want to note that as far as his contact with the victim, he did text her, or he contacted her multiple times, resulting in aggravated stalking charges. But one of note, which gave us concern, is on April 26th, saying, I don't know if I can ever forgive you. God is going to really have to help me through this time. He violated a no contact order by the victim about what he was allowed to do, and appeared as a resident in violation of no contact, so it wasn't even just virtual or verbal violations. At this point, I would object. I also want to note that we have requested $100,000 on each of these files. On the attempted home invasion, we were only given a $5,000 bond, and on the aggravated stalking, we were only given a $15,000 bond. I'm not asking for an increase today, but I do think any reduction in those already small nominal bonds would be inappropriate at this time.
Your Honor, the text message that was cited by the state is the only alleged contact that he had that makes up the stalking that's a violation of any kind of bond condition. As far as the home invasion is concerned, the only allegation that suggests he was even involved is the statement of the complaining witness. The alleged damage to the door, according to the report, indicates that the deadbolt was not broken, but the chain was. So the only way that he could have done that would have been or so far in that it broke the chain, but the deadbolt held. There's no damage to the door, which doesn't actually make any sense.
Motion for bond reduction denied.